So today, July 24th, I had a presentation at AMCHAM Myanmar dealing with the new companies law and how the 35% limit on foreign ownership of shares may or may not be controlled, expanded, or changed in a way to allow foreign investors and companies a little bit more than just 35%. And in the presentation, at the end of the presentation, they gave me this awesome gift, which I'm about to open right now. So let's check it out. So it's the AMCHAM Myanmar mug, which on the back it says the voice of American business in Myanmar. And just to be clear, this one was earned, not bought. I'm very happy about it. Thank you, Clara and Sarah, for it. So with that said, I'm here to give you guys the top 5 takeaways of today's presentation on the 35% limit to foreign ownership of Myanmar companies. Number 1. So although it looks pretty clear and pretty simple to understand, 35% is actually only 35%, which means that even though we all wanted to think otherwise, the 35% is limited to 35% foreign voting rights and 35% dividend distribution, income, and capital rights over the company. A lot of us here in the legal industry or in the consultant industry thought that it was possible to take that 35% and to use custom share classes in order to increase the voting rights of the foreign held shares, or to decrease or eliminate the voting rights of the Myanmar held shares. And that way you will own 35% of the company, but you will vote more than 35%, and you will maybe also get dividends from the company greater than 35%. However, that is not the case. On behalf of the AMCHAM Legal Committee, I contacted the Director General of DICA, which in turn said that according to their understanding and their interpretation of the Myanmar companies law, that is not possible. It comes down to the definition of foreign company under the law, which says that a foreign company is that on which an ownership interest, and emphasis on the word ownership interest, cannot exceed 35%. In turn, the definition of ownership interest includes, on subsection C, the inclusion of manipulation of voting rights on any company resolution. And since the company constitution is where the custom share classes and the voting rights will have to be modified, and the company constitution is a covenant, which in turn a covenant is a type of agreement, and of course this is the legalese, the legal explanation. The company constitution is an agreement, and thus, because it's an agreement, it cannot exceed that 35% limit. And that's basically the long short story. 35% is 35%, and I mean, it's pretty clear in the law, but I think the most important part here is just to get our heads straight that 35% limit, that's it. Point number 2, the Myanmar 65% may be fragmented into multiple shareholders. So just because you have 35% held by the foreign shareholders, that does not mean that the 65% has to be held by one company or only one shareholder. So a very basic strategy is to fragment the 65% of Myanmar held shares into 1, 2, 3, 4, as many shareholders as possible. That in turn will allow the 35% of the foreign held shares to have a bit more power and more relevance in the resolutions of the company. Now, this may be combined with a change on the threshold of resolutions in the company. The Myanmar companies law says that it is possible in the constitution to change the resolution percentage necessary the percentage necessary to achieve a resolution on specific topics. So the Constitution can say, okay, for decisions concerning X, 80% is the resolution threshold. And if that 80% is the resolution threshold, then the foreigner would have to be included in the resolution, right? The foreigner will have to approve the resolution in order for the resolution to happen. Again, this is not clear at the moment, but it may or may not be considered controlling the voting rights regarding the company resolutions. That is changing the thresholds. Point number 3 is that apparently the limitation, both the 35% limitation on voting rights and dividend rights or income, applies, and again, it's not completely certain right now, but it seems like it may apply to both at the shareholder level and the board of directors level, which means a bit of trouble and a bit of disappointment for the foreign investment community here, mainly because a lot of joint ventures stipulate the idea of keeping a very tight grip on the board of directors and essentially running the company through the board of directors, which is the usual. This comes from the subsection C of the definition of ownership interest, which includes the control, the manipulation, the influence, directly or indirectly, over voting rights on any company resolution. If any company resolution covers both shareholders' resolutions and board of directors resolutions, then that means that the 35% limit applies to both shareholders and directors. Point number 4 is that regardless of these limitations, if the Myanmar company has a permit or a license that is regulated by a Myanmar ministry, such as central bank, for example, in the case of banks, your joint venture acquisition or whichever the case has to be approved by that ministry. And if it's not approved by that ministry, everything that we've been saying here, who cares? Point number 5 is a very minor one, and that is that the new competition law may apply to some of these joint ventures or acquisitions. Again, some of the big players in the market may be considered to create a monopoly if they join together and quote unquote engage in unfair practices. So there you guys have it, the top 5 points of today's presentation at AMCHAM Myanmar on the 35% limitation of foreign ownership of Myanmar companies. Again, if you guys like the content, make sure that you click like, share, and subscribe. And we'll be bringing you a lot more content from AMCHAM Myanmar Legal Committee and from our firm as well. Thank you.